How are you? It's been a wild day today. Last couple days have been kind of wild. So, hello. And I'm glad to see everybody. Hi, I see some folks in the chat. Jackie and PJ and Sharon. Welcome. Glad you're all here. We're just going to take a little time and let people catch up here. Man, I am telling you, it has been a couple of days with the Lori Vallow trial. So we have plenty to talk about. I wanted to talk about a couple things before we launch into Lori. And I had somebody ask me a question that I thought was worth chatting about with you all. So the question was, if you are charged with the death penalty and you have a death penalty qualified jury, does that predispose them to the death penalty? And I think this is a really good question. I think defense attorneys would say it absolutely does. So if you, in jury selection, start asking jurors, you start saying to the pool, this is a death penalty case. Is there anybody here who feels like they are morally opposed to the death penalty and that they couldn't impose the death penalty if it warranted it in the penalty phase? So you start to weed out people who say, no, I could not impose the death penalty. What you then end up with is people who say they could impose the death penalty and maybe more inclined to do so if there's a guilty plea. So there is a big movement out there among defense lawyers saying that the simple act of qualifying a death penalty, qualifying a jury using the death penalty is prejudicial to their clients. And there's a lot of motions out there that continue to be filed all across the country in any death penalty state. It is certainly top of the list for death penalty attorneys to challenge the death penalty based on that. Hi, Julie. Thank you for loving my hair. I realized I need to go get my bangs cut, but I'm kind of liking the bangs. My old hairdresser used to say bangs are like instant Botox. So anyway, so I hope that answered the question about death penalty juries. And there's a couple of other cases that I wanted to get to before we really dive into Lori Vallow and her recent trial. The first one is the Menendez brothers. Now, those of you who recall know that I think it was 1982 that the Menendez brothers were convicted of murdering their parents, and they have been in prison for 30 plus years. Recently, last year, the district attorney in Los Angeles said that he filed a motion with the court asking that they be resentenced because he believed that there was evidence that wasn't presented that mitigated their sentences. Not that it mitigated their conviction, but that there was some mitigating information that wasn't presented to the jury that might have led a jury to a more lenient sentence. Specifically, that one of the brothers, or both, I don't remember, claimed that they had been the victim of SA thanks to their father. And later, there were some letters found. One was a letter that the brother wrote to a cousin talking about the SA long before the prosecution. The other was a letter from the father in that case, was a music manager, and he managed a boy band called, I think, Menudo. And one of those folks, one of those band members, came later said that he also had been essayed by the father. And the DA said he believed that that would should have been presented to the jury as potential mitigation for the sentence. So that DA filed a motion for the Menendez brothers to be resentenced. Then we had an election, and during that election, that district attorney was voted out and a new DA took his place. The new DA said he was going to do his own independent investigation. And following that investigation, he requested, asked the court to allow him to withdraw that motion. I think it was yesterday. The days are all running together with the Vallow trial, and I've been on Surviving the Survivor with Joel almost every day. So that judge said no, that he was not going to allow the district attorney to withdraw that motion, and that the resentencing hearing was going to go forward. So interestingly enough, a lot of the Menendez brothers' family that are also the family of the victims are in support of a resentencing. Now, if they were resentenced, that does not necessarily mean that either one of them are going to get out of prison anytime soon. It does mean that they would be eligible for parole and for consideration for release. So we don't really know what's going to happen in that case. Something happened at the earlier hearing. They went to the hearing simply to argue, the lawyers to argue whether or not the DA could withdraw his the motion for resentencing that his predecessor had made. And during that hearing, he flashed up some very graphic crime scene photos, really gratuitously. And it was very, very disturbing to the families who were not prepared for that. They weren't cautioned that that was going to happen. So that was very upsetting. And there was a lot of criticism against this new district attorney. So we will wait to see whether the Menendez get their resentencing or not. The other one I wanted to talk about is the Reed case. Karen Reed is being retried for the murder of John O'Keefe. And we have a jury. They started jury selection the same day that Lori Vallow did. And here we are, literally to the end of Lori Vallow's case. It's been going on for the better part of a week. And Karen Reed hasn't even started yet. So they really went through a much more rigorous jury selection, I think, than Lori Vallow did. I think Lori's jury selection probably would have been more rigorous had she had counsel and not been doing it herself. So they are still wrangling over pretrial motions, and there were some fireworks today between Hank Brennan, who is the special prosecutor who's been paid $250,000 to prosecute the case, and Karen Reed's team. And that, I think, is going to continue. I think there is absolutely no love lost, and more importantly, I think there is no respect between these lawyers. And that's unfortunate, but I also think that the prosecution has earned it. And I don't think these lawyers have much respect for Judge Cannoni either. And frankly, she's earned it. Watching her preside over this case is just so obvious how biased she is. you know, I mean, it really is to the point where people say there couldn't be anybody more biased than Judge Gull in Delphi, and Bev Canoni says, "Hold my White Claw." I mean, it's terrible. And you know, I think whatever the outcome, it's going to end up being appealed. So I am very hopeful that Karen Read is going to be acquitted, but we'll see. Um, you know, I think at the best the Commonwealth is going to do is a hung jury, and that would that would be insane. The idea that she's going to go for they're going to go for a third trial would be crazy. Um, so we will wait to see. Our understanding is opening statements might happen Friday, but it could be Monday. It's Easter weekend. Boston has a very large Catholic population, and a lot of families take Easter Friday off. Good Friday, it's called. So the other complicating factor is that Monday is what's called Patriots Day in Boston. And that is the day that the city literally shuts down for the Boston Marathon. So it very well could be Tuesday before we see lots of movement in Karen Read's case. In the meantime, they have filed a motion for Victoria George, I think her name is. She was the lawyer who was an alternate on the jury and was so appalled by the state's case that she joined the defense team and is working for Yannetti's law firm. So they filed a motion today for her to be a backup to Yannetti in terms of being the hometown attorney, the local attorney that sponsors the Pro Hac Vice attorneys. So Alan Jackson and Little are both from LA, and Alessi is from New York, I believe. So they're sort of safeguarding against the times that Yannetti can't be in court for some reason, that Victoria George would be there and be able to act as the sort of sponsoring attorney for the Pro Hac Vice lawyers. So yes, I think Judge Bev is very biased. I just noticed that comment in the chat. So yeah, I mean, so much money has been spent on this case. Karen Read is $5 million in debt and has lost everything: her home, her 401k, all of her retirement funds, and is living with her parents. So nobody is winning in that case, and it's very unfortunate. And Judge Bev is making the defense fight for every centimeter of ground. I mean, she is just not giving them an inch. So we'll wait to see. I think it's going to be engaging television, but I'm keeping my fingers crossed for her. So let's dive into Lori Vallow. So I wanted to, first of all, to just do a quick recap, because we haven't really had a chance to chat since they started examining witnesses. So I wanted to just start and go through a little bit, very superficially, of the witnesses. So the first witness on the stand the first day was Erwin Wierzbicki, who they all call Wiz, his colleagues, his officers. And he was a responding officer from Chandler Police, along with Robert Krautheim. Krautheim was responsible for the video of Lori's arrival at the scene and the questions that were asked of her. both of them testified that, well, I take that back. Wiz was the person who went in the house. So he cleared the scene. If you've seen the video, he's the one who goes in the door, yells, Chandler Police Department, anyone inside, make yourself known. He goes around from room to room clearing the house and checks on Charles, realizes Charles doesn't have a pulse. Robert Krautheim, in the meantime, is the one who is outside and who's waiting outside when Alex comes out with his hands up and seats Alex on the curb and continues to stand by with him. So Lori then gets her cross-examination, and Krautheim says she was very nonchalant, she was very calm, and he assumed it was because she did not know what had happened. He called her over to attempt to notify her that Charles was dead, and she said, I already know, I was there when it happened. Now that's counter to what Alex Cox says in his interview at the police station. He says Lori left before he shot Charles. Lori says she was there when the gun went off. She was just around the corner in the kitchen and didn't see it. One detail that didn't come out was that Lori sent Tylee back into the house, having to go past Charles' body to go get Lori's purse. That didn't come up during the examination. Lori then, when she cross-examined, wanted to know, everybody was calm. I was calm. You were calm. Everyone was calm. No one was, and she sort of went, you don't know me and you don't know what my nature is and you don't know whether I'm calm or all the time or not, but everyone was calm. So the officer was sort of stood by the fact that he felt that it was her reaction was unusual. The next was Kent Keller. He was he was the captain at the Chandler Fire Department, and he was on scene that day. He was the, shift captain, and he testified that he examined Charles' body and that it was unlikely that anyone had done CPR. If you remember, Alex calls 911, the 911 operator asks him if he will do CPR. She says, I'll walk you through it. And so she gives him instructions on how to do CPR. And you hear him in the background making noise like somehow he's doing all those things. But when the EMTs got there, they started to do CPR. Now, trigger warning, if you're squeamish, this might be a time to mute. The medical examiner testified that the first bullet went through Charles's heart and testified that that immediately poured blood into his chest cavity and filled his chest cavity with blood. And that because of that, when the EMTs arrived and they began doing chest compressions, there was a large gush of blood. And they said that wouldn't have happened if someone had been doing chest compressions all along. They also said that when you do chest compressions, one of the things you look for is you get to the sternum and you push down hard enough to hear the cartilage on the sternum crack. And after that, there's something of a depression there, sort of a malformation there. And that's where you're going to press. And so the EMTs that first were on the scene testified that when they started doing chest compressions, they felt that crack. They're the ones who it separates the cartilage on the sternum from the bone. And that they did that when they started chest compressions. So Lori then did some cross-examination about, well, if somebody didn't know how to do, really know how to do CPR, could that happen? And, you know, maybe the instructions from the 911 operator weren't all that great. And, you know, she tried to cast some doubt on it. She also went after them for not having treated Alex Cox's horrible boo-boo on the back of his head while they were there, even though he declined treatment. The next witness was the one Lori really didn't want, and that was Daniel Coons. So initially, he was there. He was one of the officers who responded on the scene. But in addition to the fact that he was the responding officer, the state wanted to offer him, and actually the judge allowed it. The state offered him as an expert on bullet trajectory. And Lori really didn't want this guy to testify as an expert, and there was good reason for it. So the medical examiner testified that there were 2 shots. Sorry if I'm a little restless. I've been sitting in this chair all day for 2 days and my butt's tired of it. Anyway, the medical examiner testified that the first bullet hit Charles square in the chest, penetrated his heart, came out through his back just to the left of his spine. That bullet went through and through and lodged in the baseboard of the living room wall behind him. The second bullet had a completely different trajectory. It entered his abdomen in an upward trajectory and came out behind his left shoulder. So when the trajectory expert was asked, he said, well, the most likely way that you get there is that the shot to the heart was first. Charles fell backwards. He was on his back, and Alex stood at his feet and shot one more time. A coup de grace shot. And that shot entered his abdomen because of the angle, because he was shooting from his feet. That meant that the bullet traveled up and exited his left shoulder. So initially, when they found that slug, that projectile, there was an exit wound. It had come out and it was on the floor near Charles's body. So the medical examiner said when he examined that exit wound, the wound was shored. What that means is that it was up against a hard surface, so that when the bullet penetrated the skin, exiting the skin, and hit that hard surface, it caused the edges of that wound to mushroom out. And that's called shoring. And so then this officer testified that the EMTs rolled Charles's body to look for exit wounds and to check for injuries on his back. And then they rolled him back flat. It wasn't until hours later, when the crime scene investigation was all done and documented, and they were able to move Charles' body. The medical examiner came and got his body, and the officers cleaned up the blood, that they saw that there was a defect in the floor, that there was actually a bullet strike in the floor right where Charles' left shoulder had been. So they believe that that's where the bullet struck. That was the path of the bullet. So Lori did her cross-examination. She did her very best to try and call into question this guy's expertise. And when she couldn't really poke holes in his story, then she grasped on to a line in his report where he said, shoring, it can be caused by the body being up against a hard surface like a floor, or it's sometimes caused by tight clothing, like lycra, like bike clothing, or tight clothing, compression clothing. Lori seized on that. So the first thing she asked him is if he knew what a bamboo shirt was. And was he aware that Charles was wearing a $200 bamboo workout shirt? I don't know who wears $200 workout shirts. I don't. And nobody I know does. But she then asked him if he understood that bamboo was a heavy-duty fabric. And she tried to get him to agree that the shirt could have caused the shoring. What the purpose was in that, I don't know, because she wasn't trying to make the argument that Charles wasn't lying on the ground when he was shot. And they stipulated that there were 2 shots. So it's hard for me to understand where she was going with that, other than just kind of trying to poke holes in their story. But it didn't really hold. So this witness basically was very instrumental in establishing that Charles was standing up. He was shot once through the heart, fell back, the trajectory then. And I think this is the most sort of important for the state's case, is that if you are shooting someone in self-defense, now it is true that there are, that oftentimes someone who is not accustomed to shooting and isn't trained might keep shooting and just keep pulling the trigger. That is a common occurrence. Someone who's very upset, hyped up adrenaline wise, all of those things, that they might very well shoot someone and then just keep pulling the trigger. That's not what happened here. So what the jury heard was Charles was shot in the chest. He fell backwards with his arms by his side, and then the medical examiner said it could have taken several minutes for Charles to actually die from the heart shot. His death was pretty much inevitable, but it may have taken him a while to die. And so I think that the prosecution has a great opportunity in closing to say he stood at Charles Vallow's feet, looked him in the eye, and pulled the trigger again. Because that's certainly what you can infer from all of that evidence. And so I thought that was a really important testimony. So the next person was the juiciest in terms of, I don't know, the whole salaciousness of it. And this woman, her name is Nancy Jo Hancock. She met Charles Vallow on an LDS singles website. And she met him, I just started talking to him on this website a week before his death. They texted for a while. They started by connecting through the messaging on the website. Then they exchanged phone numbers and they started texting, and she said they had several lengthy phone calls. She said at least one of the calls was over 3 hours long. So they were really getting to know one another on the phone. She was living in Mesa, Arizona, and Charles was in Houston. So when he came into town to see JJ and to do this supposed intervention of some kind with Lori, he made arrangements to meet her, and they had dinner the night he flew in, the night before he died. She very likely was the last person other than Lori and Alex to see Charles. They had a very nice dinner. They stayed at the restaurant from 7 until they closed at 10, and then they stood in the parking lot and talked for another 45 minutes afterwards. And they agreed that they were going to try and meet up again the following day. So he then that morning went to Lori's. She knew he had told her he was going to go to Lori's. He also told her that he was meeting with a realtor looking for a house in the area because he wanted to be moved back to be closer to JJ. One of the important things this woman testified about was that in their conversation over dinner, he told her that he had changed his life insurance policy, changed the beneficiary on his policy from Lori to his sister. And they had a fairly lengthy conversation about it. And she said to him, "You should tell Lori that you've changed it so that you'll be safe." He kind of laughed and said, "Yeah, maybe I should." So the direct examination was pretty straightforward. And then Lori got up, and that's where it got spicy because she sounded like a jealous wife. She went after this woman. "Did you know he was married?" "Well, he told me he was in the process of a divorce." She said, "Well, there wasn't a divorce." And she got called down several times for using her questions to try and testify. And she got called down a couple of times for harassing or being argumentative or harassing the witness. And so she got very argumentative. She also spent the entire time calling Charles her husband, even though at that point they were separated and she was having an affair with Chad Daybell, who is now her husband. So Nancy Jo was very poised. I'm sure she had been very well prepared, and she was very poised. At one point, Lori said something about, "So you spent your whole day talking about me?" And she said, "Don't flatter yourself. We didn't spend the whole night talking about you." She also said, Charles made me believe that he was done and that he was going to be filing for divorce, that he'd filed once before, it had been dismissed, but that he was going forward with divorce. So I thought it was interesting because the prosecutor on a couple of occasions objected and got the judge to kind of set the ground rules in front of the jury for how Lori was to behave with this witness. But she also let her and didn't object to some of the questions and let Lori hang herself into looking like a jealous shrew. So then it was really interesting because Lori said to the woman, "So what did you talk about me? You know, what did Charles say about me? What did you talk about?" And the woman said, "You want a narrative? You want to know all this?" And the judge said, "I think the prosecution objected," and the judge said, "I think we need a sidebar." So what they've been doing in the sidebar is, and they've done this in some other trials we've watched, everybody who is part of the sidebar, it has a headphone and a microphone. So they turn on white noise in the courtroom, and then they talk through these headphones, and that way Lori doesn't have to get up and go to the bench, because we know she's not allowed to move around the courtroom freely because she's in custody. So, and she's wearing a taser belt. So she is not allowed to move anywhere but from her table to the podium where she asks questions and back. Her paralegal, her people at her table take everything to the witness that she needs to have given to a witness. Now, the judge also said that those same rules had to apply to the prosecution, so that it didn't look weird that Lori wasn't allowed to move around the courtroom. So the prosecution's been constrained a bit in how they move around. But what that means is nobody can go up to the bench for a sidebar. So it's all being done over these headsets. So the judge has been, after a sidebar, when the jury is out, been sort of recapping what's decided at sidebar and also talking about jury questions. But at this point, the headsets weren't working. They couldn't get the sidebar system to work. So the judge had the jury go out, and then he had a sidebar outside of the presence of the jury. And so he looked at Lori and he said, "Do you really want to ask that question?" And she said, "Well, how do I know what lots of things is? Or, I need to know specifics." And the judge said, "I'm not sure you want to open that door. That is probably something to think about." And they were right up against the lunch break. So they decided to go to lunch. And after lunch break, when Lori came back to continue her cross, she did not go there. So, and that probably was wise on her part, as much as she really wanted to go after Nancy Jo. So Nancy Jo did admit that she had texted with Kay after. What Nancy Jo said was, Charles died in July. When she texted him the next day, and they had talked about meeting up, and she had thought, their date went really well and she liked him. They were supposed to meet up later that next day. And of course, Charles was shot. So she texted him, he didn't respond. And so she thought, wow, I guess I thought the date went a lot better than he did, and he's ghosting me. So she tried to call him, she tried to text him, he didn't answer, and she didn't try again. So it wasn't until December when she heard on the local news, this, of course, now this is the time frame where Lori's now in Rexburg, the kids are missing, she's married Chad Daybell, she's in Hawaii. So all that stuff is happening. The judge has ordered her to produce the kids. All that is happening in December. And she hears on the local Phoenix area news about this guy who's been shot, and it's Charles Vallow. And that's the first time she learns that Charles had been killed. She then reached out to Charles's family, to Kay, to sort of offer her condolences. So Lori made a bit about that she'd been in contact with Kay. It was interesting, though, because toward the end of that conversation, Lori then comes back with, you knew you were dating a married man, and you knew that we weren't divorced. And Nancy Jo looked up and said, "Well, you were having an affair, and I think he just thought the marriage is over." So that got in there. The next witness, this was the third day of trial, by the way. The next witness was Christina Atwood. She was one of the women, along with Serena Sharp, who were at these castings that Lori did to cast out the evil demon from Charles. They both testified that Lori called them zombies, and referred to them by the letter Z, people who were possessed, and also that she told both of them that Charles was possessed by a demon named Ned Schneider. Lori kind of went after both of them. She went after them about how she didn't know them very well. How did they know her? And really tried to sort of mean girl them. I don't think it was very effective, and I think the jury kind of saw through it. But on day 4, Serena Sharp actually was on day 4, but before her was Adam Cox. Adam Cox is Lori's brother. And Adam is the one, he was good friends with Charles Vallow. They'd been close friends. And in fact, they actually had a startup business together at one point. So they were good friends. Adam was the one that Charles reached out to back, and I'd have to look at the exact timing, but before Charles died, after Lori started, met Chad Daybell in October of 2018. He went to Mesa for preparing a people conference in November. He stayed at her house. That's when they got burner phones, and they started this hot and heavy communication back and forth. Sometime early in that year, Lori flew to Idaho, and then Chad flew back to Arizona with her. And so they were already on pretty hot and heavy. Lori established a fake email account that was from some woman, appropriately enough, Karen. And she was contacting Chad, and she sent an email asking him if he could come and speak to their youth at some conference as a pretext to get him out of the house so he could meet Lori. It was all a fake. Well, from that same email address, Chad, that same email address was a letter purported to have been written by Charles Vallow reaching out to Chad, telling Chad that he wanted to write a book and he wanted Chad's help. He wanted Chad to ghostwrite a book. It was completely fake, and it was made up to give Chad, once again, an excuse to come to Arizona. I'm sure that they figured that they could get quite a few trips into Arizona if Chad was supposedly helping this guy write a book. So Charles found the email, and he sent it to Adam and said, "Can you believe this is what she's doing? She's trying to give her boyfriend an excuse to come to Arizona." So they traded emails back and forth and text messages. And Adam decided that he was going to, Charles asked him if he would come to Arizona, and they would kind of, in a united front, try and confront Lori and sort of shock her back into normal. It was a fool's errand. It was so naive, but I think Charles had the best intentions. He was a good guy, and he cared about Lori, and he saw that she was seriously going down the tubes. So Adam came to town. Their intention was that they were going to get their bishop involved, and hopefully they were going to get Lori suspended, get her temple recommend suspended, because she was spending hours every day in the temple. And they hoped that would be enough to shock her back into reality. It was crazy, but that was what they'd hoped. So Lori got wind that there was this intervention happening, likely through her sister Summer. And that's when they determined that, so there were a couple things that had happened. After Charles got the email, He then emailed Tammy Daybell to tell her what was going on between Chad and Lori. We know from the Idaho trial that Tammy Daybell received those messages and blocked Charles from sending any more messages to her. So, probably one of the most important things that was brought out was the whole issue of Nephi and Laban. So early on, and it's really one of the text messages that sort of shows that Lori and Alex were planning something. There was a text message before Charles died that said, it's all coming to a head. We will be like Nephi and Laban, basically. The story in the Book of Mormon of Nephi and Laban is that Nephi was sent to recover silver plates. Lord knows these are not the golden plates that Brigham or that Joseph Smith used the magic glasses to decipher. These were some other plates, but Nephi was sent to get them from Laban. And when he arrived, Laban was drunk, and the Lord directed him to kill Laban. So very, very pointed when you think about what they were doing. So Lori said, the Lord says, I'll be like Nephi and Laban, and so will you. So they asked Adam about the story of Nephi and Laban, and he explained it. So that was important for the jury to know. Then Serena Sharp, who we have also talked about. And then the next person was William McDonald. He's from Chandler PD, and he does the digital forensics. So he was the one responsible for doing the extraction on Lori's phone. The next person was Marissa Francisco. She was a forensic scientist. There was not a huge amount of forensic information. There were some fingerprints that were inconclusive. There was no blood. One of the things they made a point of was the fact that Alex Cox insisted that Charles had hit him in the back of the head with that bat, and there was no blood on the bat. There was no, and Lori gets into it with Duncan, who was the case agent later over the bat, but we'll get to that. So there wasn't a huge amount, and neither one of their examinations were particularly long. The last person on day 4 was Kay Woodcock. Kay Woodcock was Charles's sister. She was also JJ's grandmother. JJ was adopted by Lori and Charles. JJ was the son of Kay Woodcock's son and his girlfriend. The son's name is Todd Trahan, and the mother, Mandy Leger. And the mother actually died of a drug overdose a couple years ago. So they had JJ. JJ was born drug affected. He was removed from the parents at birth. He went home from the hospital in child welfare's custody and was placed with Kay and Larry Woodcock. And Kay and Larry took care of him. Charles Vallow then proposed that Lori and Charles adopt the baby. He definitely had some special needs, and they were certainly in a much better position. Lori was a stay-at-home mom, and there were a lot of services available for kids with handicaps. So they were, it was sort of decided that Kay and Larry would let Charles and Lori adopt JJ. He was about 2 when he was adopted. He was 7 when he died. So Kay talked about her close relationship with Charles. She talked about how when Lori disappeared, she came to Houston and took care of JJ. She talked about that she'd been close to Lori, that she'd loved Lori. And then by the end of the Lori cross-examined, she was shaking before she got up to cross-examine Kay. She's afraid of Kay. And Kay was pretty conversant, pretty tried to be as unemotional as possible. But when they got to the point toward the end, she said, I knew you had something to do with his murder. It was the first time the M word came up. And I mean, obviously that's the charge, but it is not, they've been careful to sort of avoid that word. So that was the first time it came up. On day 5, that was the end of day 4. Day 5, Dr. Derek Baumgartner took the stand. He's the medical examiner. It was Colby was there, and it was very, very upsetting for him. He was visibly shaken because this was the place where all of the crime scene photos were introduced. I was very glad Kay wasn't there. Kay opted not to be there for that day in Lori's trial. Larry stayed and was there for the autopsy photos, but Kay did not, and I don't blame her. So I've talked a lot about what the medical examiner had to say. Oh, that's right. That's a good point. She did, in her testimony, say the last day she saw JJ was a particular date in May. I'm sure that the jury has sort of gotten the drift that maybe something untoward has happened to him, but it clearly hasn't come up. We'll get to what's going on with Lori, and I will add that I think that's maybe one of the reasons why she's decided not to testify, because she didn't want to open that door. So the medical examiner did point out several things that I thought were interesting and important, and they're significant when we get to the officer who offered the timeline. Because when the EMTs came in to try and care for Charles, one of the EMTs noticed that the body had already started to exhibit signs of lividity. Now, lividity is one of those signs for how long someone has been deceased. When the heart stops pumping blood through the body, gravity takes over and the blood begins to settle to the lowest point in the body. So very often you will see discoloration, almost looks like bruising or mottling at that low point in the body. So one of the EMTs commented that as they were doing resuscitation kinds of activities, when he realized that lividity had already begun, he pretty much knew they were not going to be able to resuscitate Charles, that it was likely going to be a death. Lori didn't have too many questions for the medical examiner. I think that's somebody else that she was a little intimidated of. The next witness was Mark Sari. We saw him in her Idaho trial. He is the Social Security investigator. What we didn't see from him this time was any discussion of her failure to notify them of the children's deaths. We did see a failure for her to notify them of her marriage. So he kind of went through the steps that she took to get Social Security. She then got up and sort of tried to say, what do you mean you don't have record of a notification? You don't have a notification of my marriage from the Social Security office in Hawaii? No, we don't. Are you sure? Couldn't you have overlooked it? Maybe they didn't tell you, and those sorts of things. So he was adamant that that was not the case, and that she would not have continued to qualify for benefits as a mother taking care of a dependent child once she was remarried. JJ still would have been entitled to his Social Security, being a dependent child of a deceased father, but the additional grant for mother grant would have ended upon her marriage. Of course, it also ended with the death of the children. So basically, she made all of those applications in August. She got paid retroactive back to Charles's date of death. And then the children died in September. So from September on, she was receiving benefits illegally. The next witness was Jeff Moberg. He was firearms and tool marks. This is not a case of trying to identify what gun committed the crime and who pulled the trigger. So these folks he didn't have a lot really to add about the slugs and the tool marks. They have the gun. Alex said it was the gun he used. He admitted he shot Charles. So there's not a lot of trying to put pieces together and figure that part out. The next witness was Cassandra Inclin. She is the officer who appeared on the scene, drove Lori and Tylee to the Chandler police station, and then interviewed them both. She is the female officer who was involved. If you've seen those, we saw them in the last trial, the interrogation videos. And so she testified that Lori's behavior was odd, that she was unemotional and nonchalant. She testified that they are not allowed to bring much in that Tylee said or did. So she essentially testified about her interview with Lori, that Lori was very nonplussed by what had happened, that she took Lori back to her house. They were not allowed to use either of their cars because they were within the crime scene perimeter, but they were allowed to take Charles's rental car, so they took that. She later called Lori when the officers on the scene said they hadn't recovered Charles's phone. She called Lori and said, "Do you know where Charles's phone is?" And Lori told her she had it. So they asked Lori to come back. She walked up to the window, and Tylee picked the phone up out of the cup holder and handed it to her. So there was some back and forth about, didn't we give it to you willingly? No, we did. Yes, you did. I mean, it didn't really have much impact. She was on the stand most of the afternoon on the fifth day and part of the most of the morning on the 6th day. And she went through very painstakingly through the case and what happened. And the next witness was Ariel Werther. He is the GPS expert. He was the guy who went out and collected up all the videos, the video from Burger King, the video from Walgreens, and the school and all of that. So he was the one who was out sort of shagging down all that evidence. He also was the one who used the GPS location data off everybody's phones to create a diagram of where everybody was and at what time. He's the one who discovered, as he was putting the timeline together, that it was likely there was 40 to 45 minutes that after Charles was shot before Alex actually called 911. He also testified that during that time, Alex had at least 2 phone calls with Lori. So, and I think that was really damaging, just being able to put in front of the jury and say, here's the map. Here was where Charles was. Here was where Lori's was. Here's where Alex was. Here, and to be able to put that graphically up, and then to say, that's when the aha moment, when I realized that Lori left. She says she heard the gunshot before she left, that Charles was shot just before she left. She got in her car and left. They have Charles's phone that has his location services turned on. So they track his phone and they know where Lori was, where Alex was. And they know that Alex didn't call 911 until 45 minutes after Charles was killed, which is borne out by the fact that lividity had already set in his body. So the last witness took the stand today, and that was Detective. They ended early yesterday. They apparently had perhaps Detective Duncan scheduled to come in, and it didn't work out. They didn't have a witness. So they ended early yesterday, and Detective Nathan Duncan came in today. Now, originally when the case started, Detective Moffat was the case agent, but Nathan Duncan had been doing work on this case since the beginning. He was actually there, went to the scene, helped with the evidence collection on the scene, and then has been involved in one way or another with the case ever since. But it wasn't until 2020 that Moffat got promoted and Duncan took over as the case manager. Interesting little detail was a bit of new information. When Lori took Charles' phone, after she came back to the scene, after they went to the police station and were interviewed, and Detective Inkling took them back to the house where they picked up Charles's car. They all drove, Tylee, Lori, and Alex. They picked JJ up from school, and they all drove to Alex's house in Santan, which is another suburban south of Phoenix, another suburb. So they went there. And one of the things that turned up was photos, not even screenshots, but photos where they went through Charles's phone once they had it. Now, we knew Lori knew the password. I know my husband's password. He knows mine. They're the same. But Lori knew the password. They took the phone. They went to Alex. And once they were there, Alex put Charles' phone on the counter and pulled up some of his text messages and took pictures of the phone sitting on the counter with the text messages. Some of the text messages were between he and Adam, coordinating times, Adam's flight information, those sorts of things. So it was kind of like saying, see, I told you so. These prove that they were planning something. And so they found those in Alex's iCloud. So Detective Duncan really had the job of sort of going through, kind of playing the wrap up. If you remember, during Lori's trial, they called Ray Hermosillo to the stand. I think it was him. And he did the sort of sew up all, plug all the pieces together, put it all together, connect all the dots, however you want to say it. And so that was Detective Duncan's function, was to come and sort of connect the dots. So he did a good job with that. But here we are, it's the 7th day of trial, it's after lunch, and the prosecutor, and I have to say, this has not been her MO. Trina Kay has been pretty good. But she got into this like slow drone while she was asking him questions. And there was a moment that I just thought, oh man, she is losing this jury. It is after lunch. It is warm. It's the end of a very long, for the jury, really long days, a long trial. And I think she better pick it up. I also thought the way the prosecutor presented it was to say, once Charles Vallow died, did all of a sudden Lori and Chad start openly texting romantic texts and sexy texts back and forth? And she kind of approached it from that. The minute he was dead, they started openly being together, texting and whatever. I thought she made a mistake by not bringing in evidence that this affair had been going on for a while, because I felt like it gave the jury motive. The jury could say, okay, so we know she wanted his $1 million life insurance policy. They got very deeply into that. We had the insurance, the person from the insurance company who talked about changing the beneficiary and all of that. So it's very clear that they were disappointed that they weren't going to get $1 million. But I thought she sort of dropped the ball in not telling the jury this affair had been going on for months. And this was the motivation. Part of the motivation to get rid of Charles was because these guys wanted to be together. I didn't feel like she made that connection. I also felt like it wasn't really until we got to Ariel Werther, who did the timeline and the phones, and Detective Duncan, that we really started to get that conspiracy connection. Before that, I was worried that they were not doing enough to connect up those dots for a circumstantial case. So we got to the end of Duncan's testimony, and Trina Kay said, prosecution rests. And so then the judge went to Lori Vallow and said, oh, she made a motion for a judgment of acquittal. It's essentially saying that the prosecution didn't prove their case. The judge very perfunctorily said, taking all of the evidence in the light most favorable to the prosecution, which is the rule, I find that there is enough evidence that a jury could find beyond a reasonable doubt that you're guilty. Now, that is a decision that is done outside of the jury's presence, because we wouldn't want the jury to hear that. And so then Lori Vallow said, the defense rests. Well, you could have knocked my chin off. I was on with Joel, and I just stood there and went, because I was very surprised. All along, she has said she wanted to mount a defense. She wanted to be heard. I think that this did not go the way she had hoped. The judge did constrain her and put guardrails around her and insist that she comply with the rules of evidence. She was not able to spin her narrative. Now, what she does in closing arguments, we'll wait to see. But to this point, she has not been able to spin her narrative. And I think that she decided that she was not going to be able to get on the stand and spin her narrative, that she might as well not do it. Because if she gets on the stand, there's certainly a danger of her saying something that's going to open the door and let the jury know that Tylee and JJ are dead and she was responsible. So I think that's a big risk. And weighing the risks and rewards, she decided not to. So then the judge said there was a lot of hemming and hawing about scheduling. Initially, the judge said, come in tomorrow morning, you will do your, we will do the jury instructions conference, and you can start closing in the afternoon. Well, then the prosecution asked a question. Lori said, oh, the prosecution said, we don't want to do closing and then end up not being able to do rebuttal until Monday. So there was talk back and forth. Now, Friday is Good Friday. Some organizations are closed. I don't know about the court. Originally, last week, they didn't do Friday, so I don't know whether Friday is just not a trial day or whether it's off because it's Good Friday. Monday is what is called Patriot Day in Boston. So that's going on with the Reed case. And we talked about that. So I don't really know whether the court had intended not to have court on Friday or not, but they decided that they weren't going to start closing arguments until Monday. Now, the prosecution came up and stood up and said, we would like Lori to put on the record, like the jury brought in, and for her to rest in front of the jury. And the judge, Lori said, no, I want to do that Monday. And so the judge said, well, you know, it's not really effective until you do it in front of the jury. So he told her that she did have time to change her mind between now and Monday. I don't know whether she's going to change her mind or not. I think it was reasonable for the judge to say that because she's pro se. And, you know, if you get to Monday and she says, no, I'm still not going to testify, well, she's had 3 days to think about it and to decide that. So, you know, Joel asked me, do you think she'll testify? And I said, you know, at this point, it's a coin flip. It's 50-50. I mean, Lori is not a person who likes to be seen as indecisive. She's a person who's like, I made up my mind and I'm not changing it. So I could see that part of it. But, you know, on the other hand, she could decide that getting on the stand and being able to speak her piece is worth it. I just think she's not going to because of the constraints the judge has put on her. But when she gets to closing, all bets are off. So closings could be really interesting. It very much could get to the point where a judge is having to call her down repeatedly while she's trying to give her closing. That wouldn't surprise me at all. So there we are. Karen Reed starts next week. We're going to get closing arguments from Lori on Monday. Reed, I don't think will start till Tuesday because of Patriot Day. Tiffany Adams, the grandmother in Oklahoma, was supposed to have some sort of a pretrial conference today where they might set a court date, but I haven't seen anything on that. I did see that one of her co-defendants filed a motion to recuse the judge, and that was denied. So things are moving along there. Corey Richens was scheduled to start at the end of the month, and that has been delayed indefinitely because she has filed an interlocutory appeal. You may remember that in a case where a judge has made a ruling, usually it's an evidentiary ruling of some kind, and it is a final order, then the defendant can appeal that order. And so that's happened in Richens. I admit I have not been following that case closely, so I'm not really sure what the issue is that went up to the Supreme Court, but that's going up, and her trial isn't going to go forward until that's decided. I don't have any other trials listed for May, but then June, things get wild. So in late June, we have Crystal Rogers, Brooks Hauk, who is her boyfriend, and Joseph Larson. Their trial is going to begin on the 24th. But we have Kohberger starting jury selection at the end of July, and I guarantee that June is going to be wall-to-wall pretrial motions for Kohberger. I think we're going to see a lot more pretrial motions coming up in May and June, and then they'll start jury selection. And that trial, they've set aside 3 months for that trial. So the change of venue was granted, and that is going to be in Boise in the Ada County Courthouse, the same place that the Daybell and Vallow trials happened, Lori and Chad's trials. It will likely be in that same courtroom because that's their largest courtroom, and they will likely have overflow closed circuit in the county manager's office or meeting room. So we don't know at this point what the process is going to be for live streaming that trial. The judge hasn't made that determination yet. I do expect that it's going to be live streamed. But we don't know under what circumstances. We don't know if there's going to be rules. That we don't know if, like this Vallow case, they're going to do a 30-minute delay. We don't know any of those details yet. But as far as we know, the judge is ordering that it be live streamed. So I guess we're ready for questions. I do see, okay. Hi, Rose. I wonder if the jury wonders where Tylee and JJ are. I was hoping that it would have come out about the children being dead. So I am certain that the jury has a lot of questions about Tylee and JJ. They have a lot of questions about the fact that they have heard nothing about Tylee and JJ since Charles Vallow's death. There were a few minor mentions of JJ after Charles's death, but it's just crickets. So I'm sure that they are very curious. Kay got up and she talked about the fact that if Lori couldn't and Chad, or Lori and Charles, if something happened to Charles, JJ would come to her. And it's clear she doesn't have JJ. So I'm sure that there are a lot of questions about that. Yeah, during her testimony, she was asked about that, and she said Charles always intended that if he couldn't take care of JJ, JJ would come to me and be with us. And it was clear from her testimony, JJ's not with her. So I'm sure that they have a lot of questions. I suspect this could be something that comes out in closing. If Lori opens the door, it could come out. So she's walking kind of a dangerous tightrope at this point. Could prosecutions play that Charles video in closing? They threw in a surprise video in the Hellis trial. It couldn't be considered as evidence, and I thought that it was a bit of a mistake for them not to play that. But I suppose they could bring it in, but the judge would have to caution them that it wasn't evidence. And that's tough. I mean, why play it if it's not evidence meant to convince the jury? So I wondered all along what they planned to do about that video, because I thought it was important for Charles to be standing on the sidewalk saying, I'm worried about my children and I'm worried about what she might do. And she threatened to kill me. And, you know, I thought all of that was pretty important. And I was very surprised that they didn't offer it. But they may offer it in rebuttal because they're entitled to rebuttal, to put on a rebuttal case. So if the weird part is Lori didn't offer any testimony, but they still get rebuttal. I mean, they did it in Lori's case when Lori didn't offer any defense. So I don't know. They may be going to offer it as part of their rebuttal case. We'll see. That's a good question. Hi, musicer. I always miss that little R in there. 51. Lori sent subpoenas to victims. How was she able to obtain the personal addresses of these individuals? How did it get past any oversight or intervention by her defense counsel in the court? Okay, this is a good question. So because Lori's indigent and there are fees associated with sending out subpoenas and having them served, her subpoenas had to go through what she keeps calling OPDS. We call it here in Oregon the same, Office of Public Defense Services. They are the people who hold the purse strings and approve financial expenditures for indigent people. So she was required to send those out through OPDS. My understanding, because she told the court today, she sent subpoenas out to some of these people either mistakenly or unintentionally. She said she signed a whole stack of subpoenas, but she didn't review every one of them. So some of those subpoenas went out mistakenly. One to Bobby Vallow. He was not intended to have been subpoenaed, apparently. He is Charles Vallow's youngest brother. He's the youngest of the Vallow siblings. So those subpoenas went to OPDS. She also issued subpoenas to some of the people who were designated as victims. So specifically Larry Woodcock. And how she got the addresses and the information, well, that information, she is entitled to have the contact information of all of those people. Defense counsel typically would have that information. So here's the thing. Defense counsel gets all that information. They're also responsible for making sure that it's not used improperly. Since Lori is representing herself, her responsibility was to make sure that it wasn't used improperly, and she messed it up. So when they sent those subpoenas out to OPDS, the subpoenas went out and they were filed, the return service and the subpoenas were filed with the court unredacted, and that personal information went into the court's docket. So the state asked for those subpoenas to be sealed so that address information didn't become public record, which is right, is appropriate. But the defense is entitled to have that contact information. She's entitled to it. And so she had it appropriately and legally, but she misused it. And because she is acting as her own attorney, she's expected to behave as an officer of the court. And she was expected to follow the rules, and she screwed it up. Not that uncommon when you're acting as your own lawyer and don't understand all the rules. And I have said all along that she's operating at a disadvantage because she's in lockdown and she doesn't have access to her advisory counsel and her paralegal and her investigator as often and as freely as her lawyers would have. So when her paralegal shows up and hands her a whole stack of subpoenas, she's got a limited amount of time to be able to accomplish those jobs. It's not like she can sit there and peruse every one of them and discuss them, which she should have done. So it was a mistake on the part of her and her assistants, her paralegal. Ultimately, it was her responsibility, and she apologized to the court and said and admitted that it was a mistake. She's entitled to that information, but she's required to protect it from being released to anyone else. So, any other questions? Yes, I noticed that, Liz. Lori referred to Tylee and JJ in the past tense more than once. So did Kay. So, I think the jury is going to have a lot of questions, and they may draw their own conclusions from what little they know. So. Hey, Rachel, I want to shout out to Rachel and say thanks because she has been keeping me up to date on the Grandma, Oklahoma case and been sending me stuff when things change. And I really appreciate that because I haven't been as on top of it because there have been so many other things going on. Lori representing herself got me thinking. Is there ever a time when someone can represent themselves with a lawyer and both are active in court, or just be represented versus represent yourself? So this might be kind of an interesting question. If you remember in the Robert Hellis case out of Nevada, out of Las Vegas, he opted to represent himself. He did have standby counsel, but he was a lawyer. So it sort of was that situation where he had assistance from a second chair lawyer. It was certainly a different situation than Lori was in. But there isn't an opportunity for a lawyer and the client to sort of double team and act as a legal team before the court. So you wouldn't have the situation where you'd have Lori asking some questions and her standby counsel questioning some witnesses, or doing closings and openings, those sorts of things. The judge was very clear in this case that if she was going to represent herself, she was going to have to do the work in court. And if her standby counsel had to step in, they would be responsible, that she couldn't go back and forth. She couldn't ask them to come in and then take it back over. So there were some very clear guidelines for her, and that's typical in a pro se case. Good questions, though. Do you think the state proved a prima facie case for conspiracy? Will the verdict be guilty? I think they did. I was a little worried early on that they might not be connecting up those dots adequately, but I think they did. I think she's going to pull it all together in the closings and sort of give, make all those connections in closing. And I think they have done enough to make a case for conspiracy. So I think there is going to be a guilty verdict here. I think there's a much bigger question in the Brandon Boudreaux case. Now, we haven't seen all that evidence, but what I've seen to date, I think that the prosecution is going to have a harder case. Yes, there's no question Alex Cox took a shot at Brandon Boudreaux. And if Alex Cox were still alive, there would be no question about his guilt in an attempted murder. I think they're going to have a harder time making the conspiracy connection in Brandon Boudreaux's case. So that one's going to be interesting. And I think it is going to come up immediately after. The judge wants to just keep this train rolling. So I'm a little more worried about that one. But I think they've gotten there, and I think she's gonna put it over the finish line in closings. So good questions. Some of the jury questions seemed a little odd to me, maybe even non-applicable to the case presented. Do you think it says something about how they're processing the case? I don't know. I don't think I don't think jury questions are 100% indicative of what the whole jury's thinking about. Remember that when the jury questions come, they haven't had a chance to deliberate yet. They are not allowed to talk amongst themselves about the case. So they haven't been able to, they're not deliberating. So we don't know. And when a jury deliberates, that's a whole different dynamic. That's a whole different sort of vibe where things change and can evolve and people's minds can get changed. So I'm not so sure that we can read a lot into what the jury is thinking with jury questions. So jurors often come from a place of just sort of base curiosity about trying to understand what happened in the case. The judge is the gatekeeper and has the responsibility to make sure that the questions are relevant and that they're not too prejudicial and that they kind of follow the rules of evidence. So there were questions that the judge allowed, but there were also questions that outside the presence of the jury, the judge put on the record what the jurors' questions had been and whether they were allowed and asked or whether they were not. So they weren't, all of the questions were not asked because the judge found that some of them weren't appropriate or weren't relevant. I think that's human nature for a jury that doesn't know as much about the case as we know, to be curious about things and ask questions. And it's really up to the judge to say, I'm not going to allow that question. We're not going to ask that one. And the jury that's explained to the jury that the judge ultimately will decide whether or not the questions can be asked. So. Jackie. Hi, Jackie. Why weren't insurance calls allowed in where someone, Chad, made changes to his policy and those from Charles to the insurance company struggling to change the beneficiary? Only Lori's calls in. Okay. See question above. I ran out of room. Only Lori's insurance calls were admitted, not Charles. Oh, okay. So we heard in Lori's case that Lori changed the password on, we didn't hear about this. And I think this was a mistake as well. We heard that Lori changed the password on Charles' insurance beneficiary. And when Charles then decided to go in and change the beneficiary, he couldn't get in because she'd changed the password on his access to the website. So he then had to call the insurance company, talk to them about changing the beneficiary. They had to send him a form and he had to do it by snail mail. Would it have made a difference? I don't know, but it certainly does start to show intent. Does it show conspiracy? No, but it does show her intent that she wanted him locked out of his insurance so that he couldn't change the beneficiary. So I think it was probably a mistake not to offer that. I don't know that other than that, that it was particularly significant. Now, Chad's phone calls and Tammy's insurance didn't have anything to do with this because that predates Tammy's death. Charles' death predates Tammy's. So it's a little bit squirrely. And Joel and I actually talked about this earlier today. They couldn't bring in any information about Brandon Boudreau's, the attempt on Brandon Boudreau, and they couldn't bring in any information about the children, the case involving the children and Tammy, because Charles was still alive, and that all was after Charles died. That was on the flip side. They were able to bring in Charles' death in the Idaho case because they were able to make the case that it showed motive and plan and all of those things, and get past the 403, is it too prejudicial and not probative enough? So they were able to get past that and get that information in Idaho, but it didn't come in Charles's case because the children were still alive when Charles died. Where I think they may be able to get some of that stuff in is in Brandon Boudreau's case. They may be able to bring in Charles's death to show a plan and motive, and the fact that they didn't get Charles' $1 million life insurance, the fact that Melanie Boudreau was part of the cult, the fact that he had a life insurance policy, that they wanted to, that Mel was going to take care of everybody because she'd just gotten a settlement in her divorce and she was still his beneficiary. So I think it's possible that that's going to come in Brandon's case. What else do we have? Do you think Lori will change her mind about representing herself in the next trial? I don't know. I don't think so. I think she's sort of in for a penny, in for a pound. I don't think so. And I think at this point, if she were to change her mind, her standby counsel is going to pop in, and they're as prepared, I guess, as they can be, but they're trying to prepare for a contingency that may or may not happen. So I don't know how effective they're going to be if she were to decide that they need to come in. And the judge was very clear that he was not going to continue the case if she decided at the last minute to have her standby counsel step in. That she had opted to represent herself, and if at some point she changed her mind, that he wasn't going to allow that to delay the trials. So I think she's kind of boxed into a corner. She could, but if she does, her standby counsel is going to pretty much be in the same position she's in right now. So. Hi, Sharon. I would be very annoyed if I was on the jury and found out later I wasn't told all the facts about JJ and Tylee. I could understand a jury being upset about that, and I could understand why. Legally, the judge is required to make sure that Lori is not prejudiced by her prior bad acts. That's just the law. So they cannot bring in her prior acts as a way to prove that she acted in conformance with her bad character. I know that that's kind of frustrating and it presents some frustrating barriers, but that really is the bottom line, that she is not allowed, they are not allowed to put on evidence that because she killed Tylee and JJ, she must have also killed Charles. So let's take a couple more questions before we wrap up. Flashback. Surely the surveillance footage from the Rexburg storage facility will be allowed in the Brandon Boudreaux case. Yes, and I don't see any reason why it wouldn't be. The surveillance tape shows Lori and Chad, or actually I think it's Lori and Alex on the first one, going to the storage unit and putting the tire and the back seat out of the Jeep Wrangler into storage a day or so before Brandon Boudreaux is shot at. So clearly Alex was getting ready to leave town and go to Rexburg. The next footage shows Lori and Chad then taking that same seat, third back row seat, and tire back out of the storage unit the day after or 2 days after. So yeah, I think that certainly will come in and be probative. And there's no reason for it not to come in. It doesn't have anything to do with Tylee and JJ. It doesn't have anything to do with Charles's murder. It's all just based on what the actions that Alex did. And I'm sure that they'll have somebody come in and testify that the back window of the Jeep Wrangler doesn't open when the tire is in the way. And that in order to have access to the back hatch, you have to take the tire off. So, and the testimony is Brandon Boudreaux is going to testify that he saw that back window open and the barrel of a gun poke out, and that he believed he saw Alex Cox. Alex isn't here to refute that, and so I don't know how much of a defense Lori's really going to put on. I don't think there's any dispute that Alex Cox was there and shot at him. The dispute is going to be making the conspiracy connection, that she conspired with Alex and that one of them took a substantial step toward carrying it out. The substantial step's easy to prove. Alex took the shot, but the connection, I'm hoping that there are text messages that we don't know about. There's certainly not any that I've seen. The circumstantial evidence will be that the Jeep was in Rexburg, that Lori helped him take the stuff and put it in storage. He went to Arizona, he took the shot, he drove back and got the stuff back out of Lori's storage. There'll be testimony that his license plate was caught on license plate readers on the route between Rexburg and Arizona. And I think they can certainly connect the dots of Alex getting there. The question is whether or not they can actually make the conspiracy connection. That one I think might be a little harder. So we'll see. Chad is not a party on the attempt in Brandon's life. He has never been indicted. And in fact, In both of those cases, the prosecutor declined to indict him on either that or Charles's murder. So I want to talk just a little bit about circumstantial evidence and kind of give you my description of how I describe circumstantial evidence. So let's say that you have a jigsaw puzzle, and it's a puzzle, the cover, it's a puzzle of a garden, okay? And amongst that garden, there are several areas where there is something brown. So you have this beautiful flower garden and you're putting together all the pieces of all the pretty flowers, but there's a couple of places where there are 2 empty spots, and those spots have brown around the edges. So you've got to assume that something brown goes in there. So you keep putting the pieces together and you realize, okay, this brown thing is taking shape, but I can't really tell at this point whether it's a dog or whether it's a garden bench. Could be either. That's reasonable doubt. So the more pieces you put together, the more the shape of this brown thing, takes shape. Now you can look at it and you can say, okay, I've found all the brown pieces and it appears to be the body of a dog. I'm missing the piece of the dog's face, but I can see it's the shape of a dog. It has a tail, it has 4 legs, it has the shape of the dog's head. I can see dog ears. I just don't have that one last piece that's the dog's face. That is a circumstantial case, because you can conclude that that brown blob is a dog, even though you don't have every piece to make that whole picture. On the other hand, if that brown blob, you don't have enough pieces to figure out that that brown blob is 4 legs or a tail, you've just got a brown outline, you cannot, that's reasonable doubt. You cannot find, oh boy, my light's changing, the sun's going down, can you see that? And I have a nice bright window right here. So as the sun's going down, we're getting some weird light here. So the jury would have to find reasonable doubt, because I can see that that blob is brown and it might be a dog, but it also might be a park bench. That's where there's reasonable doubt. If you don't have enough pieces that you can infer the whole, that's a circumstantial case with reasonable doubt. So in this case, we have to ask, has the prosecution put together enough pieces that we can infer that Lori is guilty of conspiring? Are there enough pieces that we can make the inference that Lori conspired? That's going to be a question for the jury. They're going to have to take all those pieces together. The prosecution is going to do as much as they can in their summation to connect all those dots up so that they've got a very clear path to a guilty verdict. But ultimately, the jury is going to have to sit down and say, do we have enough pieces to figure out that this brown blob is a dog? So those are the questions. I don't know where that noise is coming from, because it doesn't, I'm not getting background noise in my house. So I don't know where that noise is coming from. It's almost like I hear something on oh, hang on here. Maybe I did have something, video running in the background on my other screen that just turned on. So let's take a couple last questions and then wrap it up for the evening. Now, I will tell you that if we get a verdict midweek next week, I will be doing a surprise live. It will be no surprise if we get a verdict next week, which I expect we will. We're going to have closing arguments, potentially rebuttal from the prosecution, rebuttal case from the prosecution. We're closing arguments, and then it's going to go to the jury. And I do not believe that this is a case that's going to take days and days and days for a jury to decide. I think it may take a little bit of time because I think the jury may sort of have to go through all of that, all those pieces to decide whether the blob is dog-shaped. So that could take a little while. But I think we're going to get a verdict somewhere midweek next week. And if we do, surprise, I'll be live. So thank you, Susie Gay. You're always such a great supporter, both here and on STS. I know Joel appreciates your support as well. I had so much fun. For those of you who don't know, Joel and his family were off on Friday celebrating Passover. And so Joel asked me to guest host for the live feed on Lori's trial. I did that. And then Joel has had me dip in after lunch the last couple of days to talk about the case and do the wrap up. So I've really enjoyed it. I love Joel dearly. I saw him in Tucson when I was there for the Festival of Books because he was there with his book. His book is about growing up being the son of a Holocaust survivor, and it's called Surviving the Survivor, and it's all about his relationship with Carm, and it's darling. It's a great book. I highly recommend it. So I did get a bit of news. The folks at CrimeCon have nominated my book for an award. They do an awards ceremony every year, an award program. I can't remember what they call it, but it is every year at CrimeCon, they have a series of awards for video projects, YouTubers, creators, and there's a category for books. And so my book's been nominated for that award. We'll see. But it's exciting to be among that group of people that are getting nominated. And I definitely will be going to the awards dinner this year. CrimeCon is in October in Colorado this year. So hope I'll see a lot of you there. Don't forget that they give out tickets, which are pricey, if you volunteer as a volunteer. If you volunteer to direct traffic and do other work for CrimeCon. So if that sounds like something that would be interesting to you, you'd like to go to CrimeCon, it's going to be in your neighborhood, you might think about getting on the website for crimecon.com and signing up to volunteer. So thank you, Jen. Jen's posted the, you know, I wouldn't think so, Sharon Hutchinson. Will there be a rebuttal case if there's no defense case? I wouldn't think so, but that I think is going to be up to the judge. So we'll see what happens, but I think they may have been saving that video for their rebuttal case, and that may have been a mistake. So we'll see. I want to thank everybody for being here this evening. Thanks so much for all of you that popped in while I was on Surviving the Survivor with Joel, and all of you that popped on Monday when I was guest hosting. And I'm going to continue to do that, probably pop in after lunchtime if Joel asks. Joel's got some interesting things coming up. They're going to be covering the Menendez case. He's got some guests that are going to come in and talk about it, even though it's not going to be televised. So you might want to check out what he's doing. That, and then we will be hot on the trail of Karen Reed starting next week. So thank you all. I know that there are a lot of other places you could spend your Wednesday evening, so thank you for spending it with me. Thank you for Jen, who is always such a wonderful moderator. I appreciate her so much. And I will see you next week on Wednesday, unless we have a verdict early. So I'm going to say good night and have a great week.